I'm Jared Craig, Vice President of Veterans for America First and Veterans for Trump. And you may have seen many of my videos where I'm interviewing candidates or ambassadors that are joining the America First movement. But today I'm here to speak to you about the recent Supreme Court ruling in favor of Donald Trump's qualified immunity or executive immunity that has come down the pipes today in the opinion of the Supreme Court this July 1st, 2024. The impact of this is that it's a 6-3 majority ruling. In the Supreme Court, we have different levels of precedence. If we have a 9-0, of course, that's way stronger than a 5-4. And this is a 6-3, which is pretty much a line down the ideological aisle between the 9 justices who currently sit. And there is a division in the Supreme Court between those who look at a reactive public, a reactive political world, and a sense of ebbing and flowing between current events that I believe is misplaced in the 3 dissenting judges' perspective. Now, the 6 who voted in favor of the executive immunity on behalf of President Trump, they clearly stated that this is not to support President Trump. The effect of the ruling affects all former living presidents, current presidents, and future presidents. As one justice put it, that they are ruling and speaking to the ages, so that this is not part of the ebb and flow between political pressures between the parties. And these prosecutions that have been filed against President Trump, the indictments and convictions, all being heavily laden with political interests, political purposes, and although used in the or presented in the court of law, they are really being presented to the court of popular opinion to interact or to interfere with the 2024 election. Now, the impact is this. Being a legal scholar, there's a lot of ins and outs as to how laws become laws, how they become enforced, and then how they are defined. The laws that were, I would say, reinforced today are not new laws. We've had immunity at various levels in the United States precedents for many different areas. Police have qualified immunity. Congressmen have immunity for certain activities to and from related to their official duties. And the executive branch has had executive immunity for their official acts and conduct while sitting in the executive office. This case did not create any new law. All this case did was to define that a president does have absolute immunity from their official conduct and their official acts while furtherance of their position as president. That's nothing new. Now, the impact is not necessarily a change in the law or an earth-shattering thing at the ground level, because the frequency of presidents who have been indicted or convicted is very low, and you're not going to get a lot of cases that come from the trial court segment or sector up to the Court of Appeals and back down and back and forth, which we call the distillation of precedents. That's how the law is fettered out. Because of that low frequency of presidential convictions and presidential prosecutions, that distillation process is not likely to occur. So the Supreme Court, what they in fact did is said that President Trump, as with any other sitting president, has an executive immunity for their official acts, their official conduct, and the furtherance of their position. That is not very defining as to what an official act is. That's to be determined by the trial court. And back with that distillation, bouncing between trial court, the appellate, back and forth, if that's to be defined as to what an official act is, it's going to require that series, that frequency of litigation back and forth. So I say all that to say, because of the low frequency of litigation on this issue, this ruling is going to act as a deterrent for future political persecutions through the wrongful prosecutions or witch hunts or these types of things that really are not appropriate in the first place. The other side of this is on the more current, is that this is going to undercut a lot of the litigation in front of Trump right now, with Jack Smith in the Florida case, and even in the Fulton County case filed by Fannie Willis. So the linchpin, if you would, of those cases that have not been ruled on at this point, that have not gone to the judge or the jury, is that those cases are going to lose their steam. And other prosecutors at the federal or state level are less likely to use this vehicle to offend the executive branch's immunity and to interfere with our elections. This is a small step. It might feel like a huge step right now because of the weight on things, but this is a small step towards bringing our country back to the way it should have been. We in the America First movement look at how America was at first to define the America First Now movement. We are originalist. We are not looking at the judiciary as being the creators of law, but the definers of the law created by the legislation. We're for a small federal government. We're for the majority of individual to government relationships to be handled between the state and the citizen of that state. So stand with us as we fight further and fight on for the America First agenda in support of all America First candidates and President Donald J. Trump for president in 2024.